Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from one of Washington's premier outdoor ranges, of course, that being Cascade Field and Stream Club, right here in God's country, Cle Elum, Washington. Now, it's a little smoky today because our neighbors to the north have trouble managing their forest, so we get to enjoy this every August. Compliments to our Canadian neighbors to the north. Listen, I want to talk to you about a subject of great debate amongst the 2A community, and that is this. Is there such thing as reasonable gun control measures? Is there such thing as actually compromising with those that advance the causes of civilian disarmament? And there are some on the right, some of you like to call them rhinos, I don't try to get into labeling too much, but that have in occasions, and recently in fact, compromised with those on the left and come up with what they call bipartisan legislation. The most recent of which is the Bipartisan Safer Communities Act, which was applauded at the time as being a huge step forward in rational and reasonable gun control measures. However, there's a theory that if you give them an inch, they will take a mile, and that may be proven right here through that legislation in not one but two ways. So today, let's spend a couple of minutes and let's talk about how no compromise is really the only compromise. Okay, so what we're talking about again today is the Bipartisan Safer Communities Act, which was passed last summer in the wake of two horrific shootings, one in Buffalo, New York, the other one in Uvalde, Texas. Now, it seemed rather innocuous, and there were several members of the Republican Party in both the House and the Senate that joined their Democratic colleagues and signed this legislation, applauding the Biden administration with the first significant piece of gun control legislation since the federal assault weapon ban of 1994. Now, what seemed like rather innocuous legislation was redefining several statutory terms, two of which, though, have now come to fruition in rather ugly ways. One of which affects the ability for young people around the United States to be trained and educated about firearms and archery and the sports associated therewith. And the second redefinition is now going to be used to run every single home-based FFL in America out of business. You see, one of the more obscure pieces of legislation which was amended by the Bipartisan Safer Community Act was the Elementary and Secondary Education Act of 1965. Now, what was added to it? Well, a tiny little sentence in there that says, hey, when it comes to federal funding, the following is a limitation now. The use of federal funds is prohibited under BSCA for provisions to any person of a dangerous weapon as defined in Section 930 G2 of Title 18 or training in the use of dangerous weapon. Now, at first, this provision really got absolutely no attention at all, but fast forward as we're now rapidly approaching the school season, and we're finding out that many of the junior shooting clubs and some of the firearm safety classes and some of the archery classes and archery competition and all these competitive youth sports associated with some schools nationwide, which were reliant upon these federal funds, have now been essentially bankrupt. They can no longer exist. Now, this is all part of the culture war that's going on amongst the Second Amendment community, which is obviously if they can stop young people from educating themselves in the usefulness and the utility of firearms and other weapons, well, then they are more likely to become lambs and not lions. Of course, the other piece of legislation, which was amended by the Bipartisan Safer Communities Act, was the federal definition of what it means to be engaged in the act of being an FFL, and where in the past we had to show that it was really done predominantly for income, essentially that it was your mainstay business. Now, a mere sale for profit could likely define an individual as an FFL. What's the effect of that? The effect of that is to terminate every single private sale in the United States and to implement what is better known as universal background checks. Now, most often when we're talking about these radical left-wing ideas of civilian disarmament, the statutory framework necessary to make this happen is not in place. However, in this case, the statutory framework and groundwork was laid last summer with the Bipartisan Safer Community Act. That act would have never, ever passed. There was not enough votes to pass it, but for the cooperation of those on the political right. The moral of the story is, no matter how innocuous a piece of legislation is, the minute you give them an inch, they will in fact take a mile. Their goal is not reasonable gun control legislation. Their goal is complete and utter civilian disarmament. So it is quite possible in the year 2023 that the only compromise that's tolerable is no compromise. Listen, you may have more questions about this or anything else related to what's left of our Second Amendment rights. Now, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is right down there in the description box. Now, in the meantime, I want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.